Good evening, everyone, and welcome to the lecture series for the preparation of CLAT examination 2023. In this particular lecture series, we were talking about the important areas which has to be covered in relation to the preparation of CLAT examinations, very specifically about the legal reasoning portion of your CLAT paper. In this particular lecture series, we were talking about those areas, the acts that is going to be asked in your CLAT examination, whether be it the law of contracts, whether be it the law of torts, whether be it criminal law or the constitutional law. We have covered specific areas which we have dealt with the law of contracts. We have dealt with the Indian Penal Code, that is the criminal law, and we have also dealt with the law of torts, which is talking about the different type of wrongful acts like trespass, nuisance, negligence, mischiefs, everything. In this particular lecture series, we were talking about the important aspects of the constitutions that is there. So we will be talking and we will be dealing with all the important aspects that are there and which has to be taken care of. Right now, in this particular lecture, we are going to discuss the fundamental rights. In our previous lecture, we have discussed about what exactly is the state. We have discussed about what exactly is Article 13 talking about. We have discussed about Article 14, that is about right to equality. In that, we have discussed the important aspects of equality before law and equal protection of law. We have talked about intelligible differentia. We have talked about rational nexus. We have talked about reasonable classification, and we have tried to understand that how the reservation that is given to the backward classes is justifiable according to Article 14. We have also discussed about Article 15, 16, 17 and 18, which talks about discrimination that has been talked in Article 15. In Article 16, we are talking about giving promotions in job areas for the reserve categories. Then we have talked about the abolition of titles. We are not using Lord, Sir, etc. before the names. So we have removed the titles that were earlier present, like Lord Curzon, Lord Macaulay. Now it has not been there. We don't use the titles. We don't prefix the titles when which we are giving any names to any person. So we have completed till Article 18, which talks about abolition of untouchability. Now, in this particular lecture series, what we are going to discuss is Article 19. So first we need to understand that when you talk about Part 3 of the Constitution, what we are talking about Article 12 to Article 35 of the Constitution. As I just told you that we have completed Article 12, which talks about the state. And let me show you for your better understanding. Yes, I suppose you are able to see the screen right now. So this here, if you're talking about, this is the index of your Constitution of India. And in this index, if you see the definition of the state, this is the definition of the state that has been marked and has been mentioned under Article 12. Article 12. And then you have laws inconsistent with or in derogation with the fundamental rights that has already been discussed. We have talked about laws, the different doctrines that has to be made applicable whenever there is a law which is in derogation or in conflict, if I would say in conflict with the fundamental rights. Then those laws which are in conflict or in derogation with fundamental rights will be considered as void. They will be considered as void. So that is what we have discussed under Article 13. Article 14, I have just informed you what exactly is this. Article 15, we have also completed. Then we talked about equality of opportunity in matters of public interest, employment. That is in Article 16. And then abolition of untouchability and abolition of title under Article 17 and under Article 18. So what we need to remember is that certain times what happens is that in the CLAT examination, you will be asked that assertion will be there. And assertion will be that A has been accused of disrespecting Why? Because he has refused Y to enter his shop. This is let's take the this is the fact. Okay, assertion or fact, whatever you say, and the reason why is it justified, that whether it is justified or not, because and then the reason it will be mentioned that Article 17 is talking about abolition of untouchability. Untouchability. What we need to understand is that in the end of the day, whenever there is a question in front of you when you're giving your examination, what you need to understand is that the assertions and the reasons might ask you the relevant article, Article 17, or instead of Article 17, what they might mention is Article 19. Okay, and then the option that will be provided to you is option number 1, assertion reasons both correct. Second would be assertion correct, reason not correct. Third would be assertion reason both not correct. Fourth would be assertion not correct, reason correct. So you need to understand, if there is any fact that has been mentioned in front of you, it can never be wrong because it is an assertion, it is a fact. So it can be accordingly mentioned and you cannot say that that assertion is wrong, but you need to see the reason. What exactly is the reason that has been given? If there is a factual situation that is put in front of you and then it has been asked that this particular factual thing whatsoever has been mentioned is correct or not, it is obviously correct because it is a fact. And fact can be imaginary also. But you need to understand, it is a trick to remember that whenever there is a fact and there is these type of assertions and reason questions are there, and if it is a factual question that has been mentioned, then facts will always be correct. But the reason that has been given may or may not be correct. So that is why it is important, it is perhaps very important for you to remember the name of the article and the number of the article also, how they are correlated. So Article 12 talks about state, Article 13 talks about inconsistency of the acts or the laws, which is interrogation or conflict with the fundamental rights. Then Article 14 talks about right to equality, 15 talks about discrimination, 16 talks about equality of opportunity, 17 talks about untouchability, and 18 talks about abolition of titles. So if you can remember it, you can use the mnemonics. I'll share the mnemonics with you. That will be very easier for you to remember it. And by that, what you can do is you will be able to recall each and every article, and perhaps not only the article but the parts also, because there are times when the CLAT examination has also asked in under which part this particular article has been mentioned. So it becomes certainly it is something which is it takes time for you to remember and understand, and to retain it for a longer period of time you need certain tricks and techniques, and that is why it is always recommended that if you can have some mnemonics that you can remember easily, because it is perhaps impossible for anyone to remember each and every article of the Constitution. But to remember a small mnemonics or a small story which helps you in retaining the articles along with the numbers, then it becomes very easy for anyone to retain that particular article. So with that, I would obviously be providing you with the mnemonics, so that it can be easier for you to understand and recall it. But as of now, in this particular class, we will be continuing with Article 19. We'll try to understand what are the important requisites and important facets of Article 19. And post that, we will be discussing about Article 20, which talks about the rights that has been given to the accused. So with that, let's start with Article 19. We'll discuss Article 19. And I suppose Article 19 This is what you are seeing here in front of you is the index of the Constitution. What is Article 19, 20, 21, 22, 8, 22, in the same way 23, 24, and it goes on till Article 445, but we are not going to discuss it. This is the preamble. If you remember the preamble, we the people of India, this is what we have already thoroughly studied, and you need to remember it, the important requisites of the preamble of the Constitution, because whenever the questions will be put in front of you, there will be at least one question which will be related to the preamble of the Constitution. So this is what we need to remember: equality of status and opportunity, and to promote among all fraternity, assuring the dignity of the individuals and the unity and integrity of the nations. And on which date we have incorporated it is very important, that it is not 26th of January. 26th of January, it is not the date on which we have adopted, enacted and given to ourselves this Constitution. It is the date on which we celebrate the Republic Day. But the Constitution Day, when the Constitution came into being, is celebrated on 26th of November. So this is something that we need to remember and recall, because certainly what happens is that sometimes the questions that has been put forward in front of you would be that under which of the following is classifying what exactly is the date on which the Constitution of India was enacted, adopted and given to you. So people might say that it is Article, this is 26th of January 1950. But in that scenario, it is not true. The correct answer would be 26th of November 1949. So let's start with the Article 19, which is perhaps one of the most important article, because if you know that there is a golden triangle which is related to Article 14, which is Article 19 and Article 21. These three articles are perhaps very important because these three provides the basic fundamental freedoms. And these fundamental freedoms ensures the all-round development of the citizens. So first we need to remember that Article 19, which is providing the right to freedom. So there are different freedoms that has been provided to the citizens of India, and those freedoms are mentioned under Article 19, which are the fundamental freedoms, and we are going to discuss them one by one. And when we talk about freedom, if you remember, if you have seen the movie The Spider-Man, and you might have listened to that particular famous quote of the Spider-Man also, that with great powers comes what? Comes great responsibility. So this is a famous quote of the Spider-Man, and why I'm referring you to Spider-Man, because you all are preparing for CLAT examination, and I am pretty much sure that all of you must have at least gone once and seen the movie Spider-Man, and that particular dialogue of the actor there, with great powers come great responsibility, is very famous, and it is actually depicting what exactly is the constituent maker saying to us. That whenever we have been allotted some powers, whenever there is some power that is being given to the citizens, there is always a reasonable restriction that will be applicable to the citizens also. Yes. So this is what we need to. Give me one minute. Yes. So right to freedom is under Article 19, which talks about protection of certain rights regarding freedom of speech, etc. So what are the freedoms that has been provided to the citizens? Let's see one by one. And when we talk about these freedoms, and when we talk about these great powers that has been given to the citizens, it is not like that these freedoms that has been given to the citizens are absolute. Now, what do you understand when we say the freedoms are not absolute? When we say that the freedoms are not absolute, it means that the freedom comes with certain restrictions. And these restrictions are perhaps more important than the freedom, the fundamental freedoms that has been assigned under Article 19. in respect to your CLAT examination. The reason being, the questions that will be put forward in front of you will there are shallow chances of you getting questions directly that what are under Article 19, what are the fundamental freedoms that has been mentioned, because this is something that every CLAT aspirants will obviously be remembering and retaining, that these are the different freedoms that has been there under Article 19. But what are the whether these rights that has been provided to the citizens are actually absolute, or they are with certain restrictions. So if we talk about restrictions, we need to understand that Article 19, which is providing you the different rights, it is the rights are not absolute, but they come with reasonable restrictions. Restrictions means that although you have been given the freedom of speech and expression, but you cannot say anything against or contrary to the sovereignty or the integrity of the India, which disturbs the peace and tranquility of the society. You cannot say anything. So there are certain restrictions that has been mentioned under clause 19, 2, 3, 4, 5 in regards to the different freedoms that has been provided. So we need to understand these freedoms along with the restrictions, because it becomes very important to remember the restrictions also. Not only the restrictions, but along with the freedoms, you need to remember the restrictions also. So for your quick understanding, I would just like to tell you how you need to remember it. When you talk about Article 19(1)(a), this is Article 19(1)(a). So the reasonable restrictions, if you go through it, the reasonable restriction of Article 19(1)(a) has been mentioned under here and under clause number 2. Nothing in this subsection clause A of clause 1. So this is the restriction. This restriction has been mentioned where? This has been mentioned under clause 3 of your, this is clause 2. So 19(1)(a), 19(1)(a), its restriction has been mentioned under 19 clause 2. For 19(1)(b), the restriction has been mentioned under clause 3. In the same way, Article 19(1)(c), the restriction has been mentioned under Article 19 clause 4. So this is how you need to remember that whenever you talk about fundamental freedom, the freedom of speech and expression that has been provided under Article 19(1)(a), the restriction has been mentioned under Article 19, under Article 2. 19 subclause 2 talks about the restriction. And what does it say? It says nothing in subclause A of clause 2 shall effect. Shall effect means it is a mandatory thing. So whenever you find the word shall, it means it is mandatory. Affect the operations of any existing law or prevent the state from making any law insofar as such law imposes reasonable restriction on the exercise of the right conferred by the subclause in the interest of the first reason, the first reasonable restriction. Why? How you can apply the reasonable restriction? Is first reason is the sovereignty and the integrity of India. So the first reasonable restriction is sovereignty and integrity of India. This is the first restriction over Article 19(1)(a). What is that saying? To all the citizens shall have the right to freedom of speech and expression. So you have the freedom to speech and expression. You can speak and express whenever and wherever you want to. But that speech and expression should not take away or infringe the sovereignty and integrity of India. This is the first restriction. The security of the state. The second restriction is security of the state. So you cannot go to another country and you can start providing details of the important informations of the country, the secrets of the country, and say to in your defense that what I'm using is my interest, my fundamental freedom of speech and expression. That is not true, because there is a restriction that will be applicable, which says that if you are saying anything which infringes the security of the state, then that type of speech is not covered under the fundamental rights. Friendly relation with foreign states, if it is going to hamper the relations between the foreign state and India, that type of speech or expression shall not be considered as fundamental right. Public order. So the second one is public order. If it is going to disturb the public order, the fifth one is decency and morality. Decency and morality. Often you have been seeing in your social media platform that people are using non-constitutional and abusive languages whenever they are discussing any matter. That type of discussion is not considered to be a valid, a decent communication, and it is curtailing the fundamental freedom. And that is perhaps the reason, if the government wants and if it's been seen that this type of communication whatsoever has been made on the platforms, if it is against that particular fundamental freedom, you cannot go and claim to the court that I have the fundamental freedom. I can use whatsoever language I want to, even on the social media. The moment the court will see that particular case, they will say to you that you have you don't have the right to say use these type of abusive language or indecent language or unconstitutional language whenever you're communicating on social medias, because this is not your fundamental right, because it has a certain reasonable restriction that is applicable to your fundamental rights. And one particular restriction is decency and morality. So if you are using such words which is curtailing the decency and morality of the fundamental rights of the society, then it is not covered under fundamental right, and this particular restrictions can be made applicable against you. The sixth one is contempt of court, defamation, or incitement to an offense. So these are the requisites. These are the requisites which one needs to remember whenever there is a restriction that is applicable, and how the questions would be in front of you. That will be that whether this particular restriction, that is the security of the state, is available against, and then there will be the name of the freedoms that will be in front of you, to the freedom of speech and expression, whether under the freedom of speech and expression, whether you find security of state as a reasonable restriction. This is the question. The answer would be yes. Whether under to assemble peacefully and without arms, do you find mention of security of state? The answer would be yes. How am I so sure that the answer would be yes? Because I have resorted to Article 19, Clause 3. I have resorted to Article Clause 3, which talks about that nothing in subclause B, okay, nothing in subclause B, which is, what is subclause B? To assemble peacefully without arms. Nothing in subclause B shall cause effect, the same line that has been used in the previous clause, operating of the existing law insofar as it prevent the secure state from making an imposing in the interest of the sovereignty and the integrity of India. This is the first again, sovereignty and integrity of India. Then public order. This is the second one, public order. Reasonable restriction on the exercise of the rights conferred by the subsection. So only two requisites are there. That is, first is the sovereignty of integrity of India, and then is public order. Then we see through it that to assemble peacefully and without arms, whether reasonable restriction of security of state is in question. I mentioned yes. My answer would be wrong, because there has been no mention of the security of state under the reasonable restriction against to assemble peacefully and without arms. So we need to remember the reasonable restrictions that is applicable to these fundamental rights that has been given to us as the matter of being the citizen of India. And what we need to remember here is that these fundamental freedoms are obviously coming with your reasonable restriction. So this is clear. I suppose this is clear to you that what is a reasonable restriction and how these are fundamental freedoms has been provided to us, but there are certain limitations to it. So we need to remember these limitations, how we are going to do it. That for example, if we talk about clause number article 19C, which talks about to form associations and union or to cooperative societies, how do we check what are the reasonable restrictions over this particular point? We resort to Article C, which is under this. We see that this particular reasonable restriction has been mentioned under clause 4 of Article 19. We resort to clause 4 of Article 19, which provides us that the sovereignty and integrity of India, public order, morality are the reasonable restrictions on the exercise of the rights conferred by the subsection. So this is how we remember this. The reasonable restrictions for Article 19(1)(c), form associations and unions, has been mentioned under clause 4, which talks about the sovereignty and integrity. This is obviously available, sovereignty and integrity of India. Then you have morality. Morality as the, and obviously third one being public order. So we see that in the same way, this is clear. Now, to move freely throughout the territory of India and to reside and settle in any part of India, this particularly has been mentioned under clause 5 of Article 19. Clause 5 of Article 19 talks about the reasonable restriction that will be applicable to fundamental freedom of Article 19, which talks about to move throughout India, and this one is saying that to reside throughout India. What are the restrictions that are applicable over them? It is under the interest of the general public. This is the first reasonable restriction, or for the protection of the interest of any scheduled tribe. So this is the second restriction. So only two restrictions have been mentioned for Article 19 subclause D and E, which talking about to move, all the citizens have the fundamental freedom to move freely throughout the territory of India and to reside throughout the territory of India. And there are perhaps only two restrictions, that it is against the interest of the general public. So for example, let's assume that during the Corona time period, the people were restricted from moving throughout the country. And the reason for the same was that it was in the interest of the general public that we don't allow people who might be tantamount to get corona and who are having corona and they had been diagnosed corona, and if we allowed them to move throughout the country, then there were high chances that the people who have not been the victim are also catching this virus, and because of which they might also fall ill. And there is a life-threatening disease that was there, the pandemic that was there. So it was in the interest of the general public to curtail this fundamental freedom of moving throughout the country. And that is how this restriction was made applicable to the citizens. And this restriction ensured that it is for the matter of the general public, interest of the general public, that such restrictions should be given and people should not be allowed to move throughout the country. So this is why it is very important to remember these reasonable restrictions. So I suppose that you are able to understand that these are the fundamental freedoms that has been given to you. Apart from all these fundamental freedoms are coming with certain restrictions that has already been discussed, and there is one last freedom before that freedom of after that this particular freedom or to reside and to settle in any part of the territory and to move in throughout the country, that has been mentioned under Article 19 D and E. Article 19F, which was talking about right to property. you see that there has been dotted marks which has been made instead of mentioning the article. Why is it so? It shows that this has been omitted. Omitted means it has been removed from the constitution, meaning which now right to property is not fundamental right, but rather it has been sent to Article 300A, which is now more of a constitutional right. Constitutional right. Why was it done? The reason for doing it was that whenever there was a need to uplift a particular area, let's take example that these are the different houses that has been there, and there is one house here also. Now the government wanted to build a road here for upliftment of the society. But the problem was, since it was a fundamental right of the citizens to have the right to property, the problem was that if there was any development that was needed, it was getting in conflict with the fundamental rights. And if you remember Article 13, what did we study in Article 13? That any law that is in derogation or in conflict with the fundamental right will be considered as null or void. So means it was hampering the upliftment of the society, because if you need to develop any road, and if this particular person says that it is my fundamental right, that you cannot take away or abridge my house because my house is I have the right to property, then obviously the construction would be not made possible, and it would be looking very indecent if to have a highway where which there is a house in the center and the people are passing in such a way. So it will not be actually a highway, but it rather be constructed some another thing, which we eventually never wanted. So that taking that thing in mind, Article 2F, which was about right to property, was omitted, and instead Article 300A was inserted by the First Amendment Act, which made right to property instead of fundamental right only a constitutional right. Now, some of you might have this particular question in your mind. That's any which ways the right is still there. Then what was the need of making it transferred to constitutional right and rather not let it be in the fundamental right? The first reason I have already told you, because once it becomes under the fundamental right and it is any law that is in derogation or conflict with fundamental rights, then the upliftment of the society would have not been made possible. So that is perhaps the reason it was much more needed to, instead of keeping it under the fundamental right, it was dire need to make it a constitutional right. It is not like the constitutional right doesn't have those powers, but it is obviously the fundamental rights were considered much more supreme than the constitutional rights. So that is why it was transferred to Article 19 for the upliftment of the society. And then when we say that Article 19(1)(g), it is talking about to practice any profession or to carry on any business, trade or business. Okay, so profession or to carry on any occupation, trade or business is your fundamental freedom. You can practice anything, but obviously there must be some restrictions. Will it be possible that I want to become a doctor? I have completed my graduation in law, and since I have this fundamental freedom, I have a freedom that I want to practice profession as a doctor, but I have a degree which is of law. Can I do that particular profession because of the fundamental rights? The answer will be no. The reason is this fundamental right also comes with a reasonable restriction, and that has been mentioned under subclause 19(6) of your Constitution of India, which says that there will be interest of general public, first reason on the exercise of the right conferred by the subsection. In particular, nothing of subsection shall affect the operation of any existing law so far it is related to what is related to. First, important, very important, the professional or the technical qualification. So I need the professional and the technical qualification, then only I can practice that particular particular profession. If I don't have the degree of law, I cannot practice law. If I don't have the degree of MBBS, I cannot become a doctor. So this is the reasonable restriction that was made applicable to the profession when whatsoever we are carrying. And the another reasonable restriction that was made applicable in regards to the fundamental rights was that if there is any business or occupation that was carried on by the state or by a corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion of complete or partial the citizens of otherwise. So that particular occupation cannot be carried out by the citizen. For example, if the government is in the business of manufacturing guns or weapons, then the citizens has been restricted to practice such occupation. You cannot go and you cannot say that I have chosen to print notes, currency notes, because I have the fundamental freedom to practice any profession or to carry out any business or trade. So I want to print the currency notes. Is it possible? The answer is no, because it is the business of the state and is being controlled by the state. So obviously it is the state who has the reasonable restriction, and which cannot be made possible and which cannot be entertained, which cannot be done by the citizens of India. So we have understood that all these fundamental freedoms that has been mentioned in Article 19, starting from clause number A, 19 clause 1A till clause number 1G, has reasonable restrictions, which has been simultaneously mentioned under subclause 19.2 to subclause 19.5. We have to remember under which clause, which restriction of which article of which fundamental freedom has been mentioned. I have told you the trick, how to remember it. The trick is that if you talk about 19.1a, restriction is under 19.1.2. Here it is. If it is 19.1.2, it is under article 19.3. You talk about 19.1c, restriction is 19.4, and so on, so on. This is the way that you can see under article 19.1g, the restriction has been mentioned under 19 subclause 5. Yes. So with this is subclause 6. I'm so sorry, this is subclause 6. So with this, we have completed article 19. We have talked about the important clauses which are important for you and for the reasonable restrictions that will be available. In the next video, we will be discussing about the important case laws which is related to the fundamental rights, and then we will be switching to article 20. With this, I would like to thank you all for being available in this particular video. We'll continue our class with the important clauses and the important case laws in relation to article 19. Article 19 being a very important article, and then we will shift to article 20, and after that we will be moving forward with article 21. Very important article, but perhaps these two articles are very important also. So thank you for being available in this particular video, and I will be meeting you in another video. Till then, thank you so much. Bye bye.